Hello, everyone. Welcome. My name is Ben Woods. I'm a researcher at Jobs with Justice. Just welcome you to the webinar, Sexual Harassment, the Workplace, and the Labor Movement. Um, we're going to get started in about 3 minutes. We'll give people a moment because people are slowly coming in to the webinar. So we'll give people about maybe 2-3 more minutes to log in, and then we'll get started. Thank you for signing in. Okay, welcome everyone. We're going to go ahead and get started. So once again, welcome. My name is Ben Woods. I'm a researcher at Jobs with Justice, the coordinator of the LRAN, Labor Research Action Network. The name of this webinar, we're calling it Sexual Harassment, the Workplace, and the Labor Movement. We're going to be having a discussion, pretty much as the title suggests, around sexual harassment in the workplace and the different facets and really different ways and perspectives of basic understandings of what sexual harassment is, and more in-depth and expansive definition understanding what that is. For us, it kind of came to this webinar through partially I sort of lead work we do on union orientations at Jobs with Justice. And after doing a presentation about union orientations, we someone asked about resources around the issue of sexual harassment in the workplace and in labor unions. And I actually was reached out to Robin and Casey, who are two presenters, and they had a lot of resources. And it came up when we have our quarterly webinars, and this is webinars that LRAN does 4 times a year, quarterly. And once we decided we wanted to do a webinar on sexual harassment, I reached out to both Robin and Casey, and they gladly said they would participate. So how this will go today is we're going to have 2 presenters I mentioned, and I'll sort of give an introduction to both of them. And then they're going to give a presentation for maybe 15 to 20 minutes each. And then we'll have a question and answer session time. Once they're done with their presentations, we'll do the Q&A. And if you do have a question, just within the sort of box you see, the webinar box that came up, you can, if you raise your hand, actually, if you just raise your hand that you have a question, I'll call on you, and then I'll unmute you, and then you can actually speak and ask your question once we get there. But first, to introduce the presenters, first is Robin Runge. Sorry if I'm saying your name incorrectly, is the Senior Gender Specialist in the Equality and Inclusion Department at the Solidarity Center and a professional lecturer in law at the George Washington University Law School, where she has taught public interest lawyering and domestic violence law since 2004, including in the clinical education program. For 20 years, she has consulted with nonprofit organizations domestically and internationally on violence against women issues, including development of programs and policies to address domestic violence, sexual harassment, and sexual violence in the workplace and on campus. Casey Wagner is the Director of Workplace Issues at the ILR School and the co-chair of the Worker Institute's Equity at Work initiative at Cornell University. She has specialized in the prevention of sexual harassment, gender bias, bullying, gender-based violence, promoting inclusiveness in the workplace for over 30 years. She is a specialist in curriculum development and educational programs related to labor. She holds a master's degree of social work from Hunter College of Social Work and a master's of labor and industrial relations from Rutgers University. So with that, those are our presenters. And I'll go ahead and pass it off to Robin, and she'll begin her presentation.
Great. Good afternoon, everyone. Thanks so much for joining us. Or I could say good morning, depending upon where you are in the country. If you're on the West Coast, it's still morning. It's an honor and a privilege to be a part of this webinar. Thank you, Ben, for reaching out. And I always learn from Casey. So it's been a long time since we've worked together, but we've known each other for many years. And so it is also a privilege to be with her today. We wanted to start off by asking all of you who are listening and watching a couple of questions. We want to get to know you better. So Ben, one thing that Casey and I talked about was, is there a way that we could ask folks to, I don't know, either type in the chat box, or maybe that is the best way, but just let us know who you are. What I mean by that is, are you a shop steward? Are you a researcher with the union? Are you a researcher affiliated with the university? I think it would help Casey and I to get a better sense of kind of who's on the call today. I know those are the groups that Ben has told us often participate in these calls, but I think it would help us to know who's with us today. What's the best way to facilitate getting that information from our audience, Ben?
It looks like, I think what people could do is just put in the question box. If they see on the webinar, they can just type their position, where they're at, if they're, say, a union researcher at a labor union, and name it. And I could tell you all later, be a couple minutes, people start putting that in. I think some people have already started. Yeah.
Great.
Yeah.
Is there a way that we can see that, or are you the only one who can see it?
I think I'm the one that can see it. You may look in your questions box to see if it's there, but I don't. I think, yeah, people are really putting these in. So
great. Why don't you read them? I'm sorry, I can't see anything.
It's all good. Let me see here. Oh yeah. Let's see. So an organizer, we have one person, an organizer with Unite here, based in Atlanta. Research analyst at SCIU, women's department, staff at the International Union. Someone's on their internal committee to address sexual harassment in the union. A researcher with Policy Matters Ohio.
Great.
So researcher, another researcher, Liuna, another academic researcher, union rep, staffer with SCIU, but they handle a lot of complaints around sexual harassment. Someone in the communications department, labor staff. So it looks like it's a lot of people who work directly more for labor.
Yeah, that's great. Thank you. Thank you, everyone, for typing in. And thank you, Ben, for sharing that with us. I think that really helps us both. And then second question we wanted to ask is, what are you hoping to learn today from Casey and I? Because we want to make sure, this is a broad topic. You know, I am a part-time law professor, and I was a full-time law professor for a while, and I taught a course an entire semester, if you can imagine, on this topic, and we only have a limited time together today. And so I know Casey and I want to make sure that we focus our comments in a way that's most helpful to those of you who have taken the time out of your day to join us. So if you could use that same exercise to type into the box, you know, one thing, your top thing that you hope to learn today, that would really help us. And Ben, I hate to ask you, but if you could, once people start typing in, read those to us, that would be very helpful.
Sure, no problem.
Thanks.
questions. I have questions about sexual harassment in my union that represents us. The union reps abusing their power over members. How do you create an internal union culture based on respect that reduces the tolerance of sexual harassment? Strategies for writing harassment that don't involve going to the HR or the boss. Best practices for unions to deal with sexual harassment. Hearing about strategies for unions to fight for members when sexual violence issues are not subject to traditional grievance procedures. I think we're going to touch on that actually.
Yeah.
So that's some of the ones that come in. Yeah.
Great.
Advice on how unions to handle harassment between union members.
That's a key one. Yeah.
Okay, so that's pretty general idea of some of the questions.
Great. Well, the good news is I think we've got a good set of materials, and that helps us know what to focus on, right? So why don't we get started, Ben, with the first slide that puts out what we're going to cover today. So our agenda is, I'm going to start with an overview of the law, even though nobody asked for that, which I totally appreciate. I think to get to your questions, which I think are really important, it's good for us to have a context, right? What's the backdrop? What's the baseline that our laws and our courts have provided us? And that's truly, by the way, what laws are intended to be. They're not intended to be, the peak. They're intended to be the baseline to build. And I think it's really important for us to all have a shared understanding of what our laws say and how they define sexual violence, sexual harassment in the law and in the workplace, and what they don't cover, right? Just so we have that context for our starting place. And it really will highlight why the work that all of you do in unions is so critical. Then we're going to move into exactly that, right? Which is Casey's going to take us into voice and collective representation, the union movement, and the important role that unions play in addressing and preventing sexual harassment. And actually the term that I prefer to use is gender-based violence, and I'll explain why as we talk. And I know Casey uses that same language as well. And then we're going to talk, Casey's got some great examples of models of what unions and worker centers have done and are doing and can do. And then we're going to make sure we have enough time built in for questions and answers from all of you. And then we have resources. And I'm guessing, Ben, that you'll make these slides available after the call to everybody as well. So I don't want anyone to feel like they need to be writing down urgently and feverishly everything that we cover. Okay, so next slide. So we wanted to get started by, as I said, getting to a place of a shared understanding about what sexual harassment is. This is a term of art that I think everyone walks around with an understanding that they've developed over time for themselves about what this is. But often people's understandings are very different. And because we, until very recently with the Me Too movement, didn't talk about this very much, that led to, I think, a lack of an ability to be effective in developing responses, right? It really is a power control issue. When everyone's walking around with a different understanding of what this is, it's hard to create structures to address it. And so we wanted to start with these scenarios and have you vote on whether or not you think these examples represent sexual harassment. So I'm going to read as well as you can read. You can read it yourself, but for some people it's easier if I read it. This first scenario, and all we want you to do is, and what's going to happen is Ben's going to do a questionnaire that's going to pop up on your screen that's going to ask you to say, yes, this is sexual harassment, or no, this is not sexual harassment. Okay, so Maria is a hotel worker who cleans hotel rooms at a large hotel. On one occasion, when she went to clean a room, there was a man in the room when she entered, and he asked her to go ahead and clean the room while he was in the room. So she went ahead and began to clean the room while the client went to the bathroom. After a while, he came out of the bathroom with his robe partially open, and he began to talk with her about how beautiful she was and how much he appreciated her help. As he spoke to her, he came closer to her and reached out and touched her back. As he's doing this, he mentions that he is single. Sorry, there's a typo there. He's single and alone in the city for the week. Maria begins to feel uncomfortable and finishes the one task she is doing and then tells him that she needs to leave to clean another room and will return to clean his room later. Is this sexual harassment, yes or no? So you should see a quick poll box up on your screen, and it asks you to select one yes or two no. It actually says you can select more than one, but don't do that. Just pick one. And then it's going to get a sense of what percentage of you have answered yes and what percentage of you have answered no.
So 91% of people have said yes, that is harassment.
Sexual harassment. Excellent. All right, great. Thanks, everybody. We could go back to the slides. So yeah, right. I mean, I think it sounds like we've got a really good, deep understanding of, in this example, I'm going to highlight some things that are in terms of an analysis, right, that got my attention. First of all, it doesn't have to include physical touching, right? So that's important. But here, Maria here had a conversation, and he said something to her about what she looked like, right, and that he was single in the city alone. And then he also did touch her back, right? Which doesn't imply that that was sexual in nature, and that's not necessary. But I want to say that even if he hadn't touched her, right, I would find this to be a behavior that if I were a union or an employer, that I would want my employee to feel comfortable reporting to me, because I wouldn't want my employee to go through this. And that's the other important detail on this, is her perspective, right? She shares that she feels uncomfortable. And I think that's the other key thing about sexual harassment is we're all different people, and how each person reacts and responds to something is really critical. I may not think, let's say I was in this circumstance. I don't know, for whatever reason, I might be like, oh, he's friendly. You know what I mean? But the point is, she has articulated in this line that she feels uncomfortable. It's that is really critical, right? And that's why it's so important that when Casey starts talking about interventions that unions have used successfully to shift the culture, which is what one of you identified as wanting to learn about, we need to create an environment where that worker, Maria, is actually not just going to tell us what happened, but tell us how she felt about it, right? Because that's a really key piece about this. In that she knows that this is something, hopefully, that she doesn't have to put up with. This is not a part of her job. So those are things I just wanted to highlight, right? And then the other thing, of course, is that the person doing this to her is not her supervisor, right? It's a customer. And sometimes there's some confusion there, right? That can a customer or a client do this? And the answer to that question is absolutely. And the law has evolved, and I'll talk about that in a minute, to recognize that an employer is responsible as well. Not always, but in many circumstances, and I picked a fact pattern that I happen to know is covered by the law. Does anybody have any questions about this particular fact pattern? You can put that in the box, and Ben can let me know. I also want to say the genders could be switched here, right? The hotel worker could be a male, and the customer could be a female. And I'm still going to think that this is something that I hope my employee would report to me if they felt uncomfortable. Any questions, Ben?
No questions.
All right, clarity is awesome. Let's go with number 2 then. So here's scenario number 2. Another true or false, yes or no. Jennifer has worked at a restaurant as a waitress for several years and has become friendly with her coworkers. The owner of the restaurant is having a big birthday party and invites everyone on the staff. When she first started working at the restaurant, she dated the owner for a few months, but broke it off because she thought it wouldn't be a good idea. The party is being held at a bowling alley not far from the restaurant, and at the end of it, she is one of the last ones there with the owner. The owner comes over to her and says that he has had too much to drink, and can she give him a ride home? She knows he doesn't live far away, so she agrees. When they get to his house, he asks her to come into his house with him. Once they are inside, he starts to kiss her, takes off his clothes and hers, eventually forcing himself on her. For the rest of the week, Jennifer calls in sick for her shifts. Is this sexual harassment? We've got that quick poll box again that Ben has put up for us.
90 so far. 90% have said yes.
Wow. All right.
Yeah, almost everyone's voted, and 91% said yes.
All right. All right. So let's go back to the slide. So, yeah, I mean, I think I'm with the 91%. Some key things that sometimes trip folks up, and it sounds like you all had no problems with them, are that they were previously in a consensual relationship, right? So sometimes people think, there's a great video that I'd be happy to share with this group afterward if they're interested, or you can Google it. It's on YouTube, but it's called T as Consent. And I show this all the time when I teach domestic and sexual violence at the law school. And one of the things that it highlights is there's sometimes people misunderstand and think, well, they were in a consensual relationship once, right? And so he must have thought that was okay. And she basically, consented, right? Because she consented previously when they went out. And so it's not harassment, right? Like he was just functioning with this understanding from their prior relationship, right? So clearly the majority of you did not fall into that trap, which I placed there intentionally. But I put it there because it is a very common misunderstanding, right? That because there's a consensual relationship present or in the past, that there can't be any sexual violence or rape is what happened here, right? Or sexual harassment. And that's just not true. Even if people are currently in a consensual relationship, right? If the individual says that she didn't want to have sex, right, then it's sexual harassment. It's unwanted. So that's the theme that's coming through in all of this. And again, it's from her perspective. So the other thing that sometimes trips people up is that this takes place not at the workplace, right? But there's an off-work site, an event, and then they go to his home, right? And so this is really important, right? These are still people who are coworkers. And so this began after an event that she went to that was related to work. That everyone, her coworkers were there, and so this still falls within the umbrella, right? And so that sometimes causes some confusion. But I think that those of us who do this for a living would definitely say that employers are responsible in these circumstances. This would be hard. I'll be truthful with you. And a lawyer for an employer would definitely argue to me that she consented to go into that home and they had a personal relationship and she didn't have to go and it wasn't work. It was off duty, and I'd have to litigate that. But I think the better interpretation, right, is that that's definitely within the scope of the workplace. So those are the things that I wanted to highlight. So we've got one more scenario. So Mike has a boss who hugs him while looking over his shoulder at his computer screen. He's uncomfortable, but is concerned about what will happen if he expresses his discomfort. He eventually finds another job and leaves. Is this sexual harassment? So the quick pull box should be up. I hope you had enough time to read it was a short fact pattern this time, so.
This one's much closer. Okay, so it's 58% yes, 42% no.
Yeah, right? I feel that. All right, let's go back to the slide for a second. So I totally relate to the split, right? And being the lawyer, I'm going to say that part of what I wanted to highlight here is sometimes we don't know enough, right? Sometimes we don't know enough. We don't have enough context, and that's often the case, actually. Part of the process of discovering what's happening here is making sure that we're able to get a clear sense of what each individual involved in the circumstance said happened. The first thing I want to highlight, which is obvious, but I need to say it, is that it's important we don't even know the gender, right, of the person who's doing this to Mike. And I would argue to you that doesn't really matter, right? So we have men who commit sexual harassment against men. We have women who commit sexual harassment against women. What we mostly hear about and know about, right, is men committing sexual harassment against women. And that's absolutely the majority of instances. Statistically, we know conservatively that 1/4 to 1/5 of women who are working today in studies that have been done actually since the Me Too thing hit say that they are sexually harassed at work. And then when you look at particular industries, right, that number explodes. So if we look at the janitorial industry, we look at the hotel industry, if we look at farm workers, we see that number increases exponentially. If we look at construction workers, women only make up a very small percentage of construction workers, less than 3 to 5%, and yet 88% of them in a Department of Labor study said that they'd been sexually harassed. But I want to be clear that we do know that men also experience sexual harassment because it is about power and control, right? This is a dynamic that occurs because of a culture of inequality in our workplaces based often on gender, men given more power and responsibility than women, and that power and that structure then creates an environment where abuse can occur, and that abuse manifests itself as sexual harassment and sexual violence, also domestic violence, and other forms of gender-based violence. And so I want to be really clear that sexual harassment is a form of gender-based violence, right? And the really key understanding there is it's because of the individual's gender, and in this instance, when we're talking about sexual harassment, sex. So the other thing is that really we just don't know. He says he's uncomfortable because his boss is hugging him, right? And he wants to say something, but he doesn't, and he decides to leave. I mean, he's so uncomfortable, and he has, hopefully, it sounds like in a good way, the privilege and the ability to change jobs. Not everyone does, right? So they put up with a lot because they are afraid they're going to lose their job if they speak to anyone. We know that less than 1/4 of women who've been sexually harassed, the EEOC has stated, actually file a formal complaint, and only 5% actually will trigger a process by filing a complaint with the EEOC or a state agency that enforces the law. So we know the vast majority of people who experience this don't actually tell anyone. And we need to address that if we want to create structures that are able to create safety and to stop it. So I want to say that I agree. This may or may not be. We just don't know enough about it. We don't know enough about what made Mike uncomfortable, and we don't know how the hug happened, right? So there's hugs and there's hugs, right? And we don't know if this was related to the sex or the gender, right, of the individual. So the other thing I wanted to flag here is a lot of stuff happens in workplaces. We all know this. A lot of bad stuff, unfortunately, happens in workplaces. A lot of forms of violence, a lot of forms of harassment and abuse, especially in low-wage workplaces. And not all of that is sexual harassment, right? And not all of that is even gender-based violence. And we're going to be focusing on that scope of behaviors today. But I want to make sure that we all understand that we're not saying that these are the only things that are happening. And it may be that what happened here, from Mike's perspective, was an assault because he didn't welcome the hug. But that doesn't mean it's necessarily something that we would think of as being sexual harassment. Having said that, I hope we create a workplace environment where any worker feels uncomfortable, like Mike, feels comfortable coming forward and saying, hey, this happened to me. I don't really know what to do about it, and isn't worried that they're going to lose their job if they do. All right. So thank you for your participation. Next slide. So we want to then, like I said, provide some context to our discussion and the really important information that Casey is going to give to you. This is probably reviewed to most of you, and that's awesome. So I'm going to go quickly. So the law that prohibits sexual harassment in the workplace, and I should be very clear, it's the law that's been interpreted to prohibit sexual harassment in the workplace, is Title VII of the Civil Rights Act of 1964. And if you'll notice here, the protected classes, the law states that you cannot discriminate on these bases, and discrimination means in any terms and conditions of employment. So it means you can't discriminate in hiring, firing, promotions, benefits, anything, right? And these are the 5 protected classes in Title VII, and include sex, right? So it prohibits sex-based discrimination. Notice it does not in the statute say that it prohibits sexual harassment. Next slide. So what has happened is that years after the law was passed in 1964, in the 1980s, Catherine McKinnon, a law professor who's now at the University of Michigan, wrote a law review article, and she opined that there were behaviors taking place in the workplace that women were experiencing that weren't captured in our basic understanding of sex discrimination. And I should explain that at that time, our understanding is this today is the same. Our understanding of sex discrimination would be, refusing to hire people because they are women, right? Refusing to hire people for certain jobs because they are men. This is why we see even today vestiges of occupational segregation, because as a society, we still kind of harbor these beliefs in some ways that there are certain jobs that are for women, teaching, and there are certain jobs that are for men, heavy lifting, firemen, cops, and that's changing, right? But that history remains. And so sex discrimination is really looking at denial of opportunities based on sex. Equal pay issues fall into this category. But sexual harassment, Catherine McKinnon argued, was something slightly different. It was, and she created two separate theories that you may have heard of before. There's quid pro quo, which is Latin for very direct, sexual harassment. It's either said or it is made clear to a worker, usually a woman, by a supervisor who's in a position of authority and power over that individual, that if you don't sleep with me, you will lose your job or you will no longer get good assignments, right, from me. And sometimes it's literally said just like that, right? Either you sleep with me or I will fire you. But more often than not, it's intimated in another way. The person gets angry when they're turned down and says things like, well, you better not expect to be in here tomorrow, or, some version thereof. It also includes being asked out, after work. It may not be like sex per se, right? It's more kind of, oh, why don't we go out later tonight, and have dinner. And when employees rebuke that interest from a supervisor, they often are retaliated against for not doing it. The seminal case that established the theory of sexual harassment, Benson v. Meritor Savings Bank, is actually a case involving this very thing. This is a woman who worked at a bank. She'd worked there for quite some time. She had, and her supervisor actually forced her to have sex with him repeatedly and, in fact, raped her. And what the court opined was an environment, right, that is hostile, right? It's a hostile work environment created by regular requests of this nature. So it makes you afraid you're going to lose your job unless you acquiesce. Is a hostile work environment. So in this case, she had both a hostile work environment and she also had quid pro quo. She literally had, like, if you don't sleep with me, I'm going to fire you. So we had both forms explored in this particular case. And we see even today in all workplaces both forms. But here's what's most important. In order to create a hostile work environment, it has to be unwelcome, sexual in nature, severe, or pervasive. So this is a really high threshold, right? In order to meet the federal legal definition of what constitutes sexual harassment, you have to prove all of these elements. And there's been some wonderful writing, and I can't remember if I provided the link, and if I have not, I will make sure I send it out afterward. There's been some great articles written and op-eds written, including one by two of my law professor colleagues in the New York Times last November, that really spells this out and talks about how the law really fails here, because the definition of sexual harassment, as I've described it here, and as the courts have continued to interpret it since the late 1980s, is very narrow. And it also only applies to employees. So if you're a volunteer or an intern, right, or a contractor, which is what some courts think that Uber drivers are, you don't have any protections of this kind. Right. So that's the other thing. It only applies to employees of that employer. Also, it does not clearly cover transportation to and from the workplace. It's just very, very narrow. And so I really want to emphasize to you today that the work that Casey and I do and that we want to encourage you to do with your unions that's a baseline. We don't want to have people have to wait, right, until we get to this place to try to seek assistance. This really is severe, right? And some of the cases where courts have actually found it's insufficient to establish the sexual harassment are actually fact patterns like the ones I shared with you today. And it is left to individual judges because they're assessing whether or not it's unwelcome, sexual in nature, and severe, pervasive enough, right? So this is context. And I should say every state in the country has their own law on sex discrimination. And actually some states like California have laws that specifically define sexual harassment, and they are much better. They actually do recognize that it's not just that it's unwelcome, that it has to be unwelcome as defined from the perspective of the individual who's been targeted, right? That it does include harassment by customers and clients. It clearly states this in the law, not just an interpretation, right, that the courts have made after the fact. It also includes, and is really clear, that it can be only verbal, right? That it doesn't require touching, that it can be pictures, right, of pornography, or it can be emails, or it can be a variety of other things. And that's a great evolution that we've seen in some states. But I want to really be clear that on a federal level, we have not gotten there yet. And this is why what you all do in designing and developing programs within the unions and even collective bargaining language that goes beyond what the bare minimum is that the law requires to truly shift and address this issue is so critically important. Next slide. So the next thing we wanted to talk about is, as I mentioned, Casey and I, when we talk about sexual harassment, use this term gender-based violence, which encompasses sexual harassment, but it also recognizes that there are other forms of gender-based violence that impact the workplace, and that we can't create an effective strategy or structure within our unions to protect our workers and prevent this behavior from happening if we don't acknowledge that sexual harassment is a part of a continuum of abuse and violence often in women's lives, but also in men's lives, right? And one of the things that we know about that, and I've alluded to this once already, is that sexual harassment is not just, will you have sex with me? It is up to and including groping. I have had clients who have been shoved up against the wall and grabbed by their boobs very violently, right? I've had clients who've had coworkers or supervisors or customers shove their hands up in their vagina. And this is in the workplace. And I'm sorry if I'm making people uncomfortable, but we need to know what we're talking about. There is case law that really is clear that rape and sexual assault absolutely is prohibited sexual harassment. But also in our evolving understanding of what sexual harassment is, there is actually now from advocacy that Casey and I have done, recognizing that harassment and violence that occurs away from the workplace has a detrimental impact on the workplace as a whole and on the victims themselves. It's one of those things where we recognize domestic violence, which is a power and control, a pattern of behaviors of power and control that take place in an intimate partner relationship, right, is not limited to the home. We know a lot of people meet the person that they're intimate with in the workplace, and so we see these behaviors perpetuated in the workplace. And even if they aren't working in the same place, we know that that individual employee's ability to do her job is directly impacted by threats that she may be experiencing from the perpetrator away from that workplace. They may be attempting to gain access to that workplace. And in all of these ways and others, it tremendously impacts that ability of that employee to do her job. And so an effective set of programs, and this is what Casey's going to talk about, needs to recognize all of the things I've just shared with you. So this slide actually makes us aware of the pervasiveness of this impact of domestic violence in the workplace. This study helps us understand that a fourth of employees surveyed, men and women, self-identified in 2005 as a victim of intimate partner violence. And that 44% of employed adults said that their work had been, and their workplace had been impacted, right? They had personally experienced the impact of domestic violence on their workplace. And then 64% of victims of domestic violence who are working indicated their ability to work was affected by the violence, right? So this is really a critical piece of the puzzle that Casey and I want to make sure that we're bringing into our discussion today. Slide. Ben? Thank you. So again, some more understanding that we have from data. This is, and I have all sources. I'm very, very persnickety about data. I hate it when people do what I'm doing right now, so please forgive me. But if you want any of the citations and copies of these reports, I'm happy to provide them to you. So we know that a high percentage of employee victims of domestic violence lose their jobs, at least in part to the violence. So this is everything from literally not physically being able to show up at work anymore because of the physical and emotional and psychological abuse that they're experiencing, or that their perpetrator prohibits them from continuing to work, by promising to take them to work or giving them the keys to the car, but then refusing to do so at the last minute, right? So you see excess absenteeism and then they just disappear. Also, people get fired, right? If the employer perceives that there's going to be a threat to the workplace, and instead of keeping the entire workplace safe, re-victimizes the victim, right? And basically says that your presence here is a threat instead of taking steps to ensure that the workplace is safe for everyone, right? And reinforcing to her that she has value. So that's another reason. Another reason that victims lose their jobs is because they need to seek treatment and or services to address the violence. They may need to go to court to get a protection order. They may need to relocate. They may need to meet with a social worker or a counselor or someone else, a lawyer like me, to find out what they can do to get themselves out of the situation, which takes time. But all of those services are only available often during the daytime between 9 and 5, which is when most people work. And if there's no clear access to leave or support services, people will have to make really unbelievably difficult decisions about whether or not to access those services or lose their job, right? And so we see a lot of people lose their jobs in those circumstances. As I said, 47% reported being assaulted before work. 67% said the perpetrator came into their workplace. The classic examples are she forgot her lunch, I'm just checking up on her, whatever. And then they get in there, and I've had clients literally be beaten in the bathroom. I've had them slash their tires in the parking lot, all different forms of violence and abuse. And the last statistic, I think, is the one that we need to carry with us. And that is that basically if you have a survivor of domestic violence in your union, it's going to impact their ability to do their job somehow. They may not even see that. They might not have disclosed. It may not be something that they've told anybody at work, but their concentration is slipping because they're concerned for their safety at home and their children, or that the perpetrator may come there, or other exacerbations of disabilities or mental health issues related to the abuse, right? There's so many reasons why this may be impacting the victim. And again, this is not her fault, right? She is not the cause of the abuse. There's no excuse for this. Our society is very clear about this. And that's why the employer has to take seriously their responsibility to support victims and not fire them in these circumstances. Next slide. And so just a couple more statistics around rape. We know that 25% of rape victims lose their job within a year of the assault, for many of the similar reasons I just described for domestic violence victims. And we know that there are rapes that occur in the workplace, right? So the last time this data was collected, which was in the 1990s, we were able to see that this is the federal government. Actually, it was the last time the federal government collected this data. And we do have data from certain industries that is more recent. But this is the federal government data, so I thought it was best to use this. Next slide. And then the last thing in this space that I want to make sure we don't lose sight of is that perpetrators are also employees, right? And they're also in your unions. And so when we talk about the intersection of abuse that is considered often to be away from the workplace, it really isn't, because we know we have perpetrators in our workplaces. The slide has the data, right? And that's negatively impacting your workplace, where even if the victim isn't in the same workplace, right, they're using resources in that workplace often, right, to threaten or the victim or do other things in that power and control dynamic, many of which are crimes. They are often accessing the workplace where the victim is. This all takes time away from productivity, by the way. And so that's the last thing that the slide highlights is it takes time to sexually harass someone. It takes time to stalk someone. It takes time to abuse someone. We always think about the cost, in terms of the victim, the target of these things and their productivity. I don't know why, but we never focus on actually it's very expensive to employ a perpetrator of these kinds of abuses, because that's all time when they're not doing those things. And by the way, everyone in the workplace, even if they're not the perpetrator or the victim, is impacted by this, right? I've been in workplaces where I'm seeing this and I'm waiting for someone to do something, right? I'm looking for some kind of accountability. And if it's not happening, I start to spend my time worrying about the victim. What can I do to help her? I don't know what I'm supposed to do as a bystander, and so those are really key things to keep in mind as well. Next slide. By the way, that last statistic, if you could go back for a second, Ben, is really key. There's a myth out there that perpetrators of domestic violence don't work. And that's just not true. And this is a reminder that, these are, that, again, we may have had some misunderstandings until recently in the Me Too movement and the coverage in the New York Times about who commits sexual harassment, right? You know what I mean? Like, and clearly, there is no stereotype in terms of race or ethnicity or education level, right? Next slide. So to overlap with the law, the federal and state laws that prohibit sexual harassment in the workplace, I just wanted to highlight for you that a lot of us over the last 20 years have worked very hard to create particular workplace protections for victims of domestic and sexual violence. And so the next few slides just summarize those, and the resources at the end provide more detail. So as of today, because in case some of you are in one of these states, 14 states have laws that require employers of a certain size or larger to provide employees unpaid job guaranteed leave or leave as a reasonable accommodation to victims of domestic and sexual violence. And in DC, we actually have a paid leave law, which I'm going to talk more about. So importantly, note what I'm saying here is that this is a law that requires employers to give unpaid job guaranteed leave to employees who are victims of domestic or sexual violence. The sexual violence need not to have occurred away from the workplace for the employee to be able to access this. The law does not say that the sexual assault needs to have taken place between intimate partners or dating partners, nor does it require that it took place away from the workplace. So this is something I want to flag. Next slide. So these laws enable a victim to take that leave, to go to court, to seek medical attention, to go to a rape crisis center or domestic violence program, or to obtain legal assistance, to obtain remedies and protections from the individual who committed these crimes. Next slide. And these are more details about those laws. They can't be retaliated against for using them. Next slide. And in addition to the unpaid leave laws, you've probably heard about the paid sick and safe day laws. There's been a lot of focus under the previous administration. The Obama administration really was a big proponent of paid sick days legislation. We do not have federal law that requires employers to give any paid time off of any kind. Legislation has been pending now for, oh my gosh, almost a decade, introduced by Senator Kinney. It's the Healthy Families Act. And although that law is reintroduced every year, even since his passing, that law has not been adopted. But look at all these states. There are 10 states, the 10th being New Jersey as of last week, which is why there's no comma. After New Jersey, I forgot the comma. Sorry. That have passed paid sick and safe day laws. These are often known as paid sick day laws, but it's really important to note that they provide employees with paid leave for a specific list of reasons, including to heal from injuries caused by domestic sexual violence and stalking. And I've listed some of the cities that have also adopted these laws. San Francisco is another one. Again, I could not possibly list them. There's over 45 cities across the country that have adopted these. So this is really important. These mandate that employers, if you're in one of these jurisdictions, these mandate that employers give paid sick and safe days off for these purposes. And so this is important for all of you to know in your collective bargaining agreements and when you're talking with your employer to make sure that they're incorporating these laws into their policies and procedures. And again, I have in the resource list, I have a link to an up-to-date chart that an organization called the Better Balance keeps up to date with all the cities and states that have passed these laws. Next slide. And then also in this space, in 2015, the Obama administration, President Obama signed an executive order that established paid sick leave for federal contractors. And this is something that may be more relevant for some of you than others. But it's important to note that a fourth of the workforce, slightly more than a fourth of the workforce, is actually working for a federal government contractor. So this really does affect a huge percentage of the workforce. And if you are working for one of these particular federal government contractors, and the executive order clearly defines which ones are covered, these government contractors now are required to provide paid sick days to their employees, and the regulations that the Department of Labor issued to implement this clarify that the absence can be taken for a variety of reasons, including a result of a sexual assault, for the victim or the employee to obtain counseling, relocation, assistance from a victim services organization, and a variety of other things. So again, this is not limited to domestic violence. It includes sexual assault and stalking, which may take place at the workplace. Next slide. Yep, new contracts as of 2017. And then the last thing I just want to flag in this space is that these 6 states have passed state-level laws that specifically prohibit employers from discriminating against employees because they are victims of domestic or sexual violence, right? So this is in addition to Title VII, but it very specifically doesn't just say you can't discriminate based on sex. They specifically say that you can't discriminate or retaliate against someone because they disclose their identity as a victim of domestic or sexual violence, right? So this is really important, as I mentioned, because we see these behaviors carried out in the workplace as well as away from the workplace. And so these are wonderful supplements to the anti-sexual harassment law, Title VII, and the state equivalents. Next slide. So this is my last slide, and so I just really want to tie all of this together, right? I love this slide. This is actually Casey's, and I want to give her credit because I think it's just a fabulous graphic. I told her I love this, and so she was gracious enough to let me use it to finish up my section. If you'll see, this is really how we view these intersections, right? As I said, the big overlap, if we had one more bubble, it would include all of these, and that's gender-based violence and harassment, right, in the world of work. And then we see within that all of these different forms of gender-based violence. We see sexual harassment, so that's sex-based, right, harassment in the world of work. We see workplace violence. We see domestic violence and sexual violence, including rape and sexual assault and stalking. And so we see all of these. And so when we're talking about putting together interventions and structures to change the culture, we have got to understand the root causes of all of these, which are the inequalities in our society, as I mentioned earlier, right, based on perceived or actual gender identity, right? And that the perpetuation of that and the power that those and that inequality structure that are mostly men, right, have over women, right? It's a natural phenomenon to want to maintain those power structures, which are very unequal. And that inequality, the power structure allows abuse in these forms to take place. We've got to address the inequalities in our society, in our workplaces, if we're really going to create a structure that prohibits and prevents this, right? Makes it really impossible. If people don't have power and control over each other, right, to the degree they currently do because of the inequalities in our workplaces, then these behaviors can't take place. The last thing I just want to say very quickly, because it's a question that often comes up, is that the way the sexual harassment law has evolved in the United States in the workplace, and sexual discrimination in particular, is that there have been cases brought to try to establish that discrimination based on someone's sexual orientation or their transgender status is a form of sex discrimination. And I want to be very clear that the Supreme Court has not weighed in on this. We have recently had a series of cases at the district and federal court level, both around sexual orientation and transgender status, that actually judges have interpreted Title VII to extend those protections to sexual harassment on those bases. But we don't have that everywhere in the country yet. Again, it has not been decided by the Supreme Court. So I just really want to make sure that I cover that in this because it's often a question we get. So if you have any other questions, please hold on to those because I want to turn this over to Casey.
Thank you. And it is an honor to be in this space with you. The last several months have been just unprecedented in the attention being given to gender-based violence and sexual harassment, a critical workplace equality issue, as you've heard. And we've never seen the sort of cultural engagement and energy from so many different types of stakeholders around finding solutions to harassment and using harassment to critique broader workplace and cultural power dynamics that we're seeing today. And thank you so much for being part of this movement and change. And we're talking about a multi-stakeholder approach, engaging usual and unusual suspects from an organizer's perspective. I'll talk a lot about that. Sexual harassment as a civil rights, equality, workplace safety, job jeopardy, job security issue. It can go on and on. Harassment doesn't happen in isolation. It's a stark expression of power imbalance and inequality, and change just can't focus narrowly on sexual harassment because many people experience discrimination based on multiple and intersectional identities, and we need to focus on cultural change. The narrow definition of the law will not make for cultural change. And so what I wanted to just highlight in this montage and also lift up is the important contributions, as the Splinter News video that you might have seen identified, that Black women historically have led the fight against sexual harassment. And that modest video is a really good montage of benchmarks. And I encourage you to review it if you haven't, and think about how you might use it in opening this topic up at membership meetings, conferences, conversations with folks. And I also want to bring back, I want to bring the voices of Black, brown, immigrant women, low-wage women, LGBTQ activists into the virtual room, whose courage, resilience, and organizing continues to lead the way, as I just flag the pictures on the screen and mention some strategies that might also resonate with you, your organization, and your constituents, as I will be talking about worker and survivor voice and collective representation, both in the traditional union and social justice context. So there's Tarana Burke in the upper left of your screen, whose groundbreaking work originated the Me Too hashtag, a racial and gender justice and survivor-centered strategy. And a little bit later, I'm going to talk about the idea of partnering with community-based organizations when we look at that continuum of what constitutes gender-based violence. In the middle of your screen, you'll see the Dear Sisters letter from farm worker women in solidarity with women in Hollywood who have been fighting sexual assault in the field, and who, with domestic workers, will be lobbying in Washington on April 24th to call on Congress to extend Title VII, as both farm workers and domestic workers have effectively been excluded from federal law protection since the Jim Crow era. So that framing of engaging with allies and community to partner as unions is critical to building solidarity and cultural change. To the left of the Dear Sister letter is the coalition of Immokalee workers, who many of you may know have completed their courageous national freedom hunger strike and continue their corporate campaign against Wendy's. And their Fair Food campaign is centered on worker, leader, and worker-to-worker education and mechanisms for complaints and accountability with the Fair Food Standards Council to address harassment and modern-day slavery in the fields. A really great example of worker-driven social responsibility. And under that image is a picture of the Yabasta Coalition, a group of allies, including the Maintenance Cooperation Trust Fund and SEIU's United Service Workers West, that illustrate a leadership empowerment strategy led by promotoras, Latinas working as janitors, to address sexual assault, harassment, and industry accountability in the janitorial industry, which was initially exposed by the film Rape on the Night Shift. So that intersectionality of this continuum is very real, as you all know. And in the center is a report called Hands Off, Pants On, that was inspired and led by women workers and leadership of HERE Local 1 in Chicago. And what I love about this is that it was a participatory research initiative that resulted in worker voice defining the scope and range of what constituted harassing behavior that Robin identified in one of the case studies from clients who were guests in the hotel and hospitality industry. And what was so powerful about the engagement of worker voice is that they defined it on their terms. They also were able to inform a panic button collective bargaining and a city ordinance initiative. And they also worked with union men from the Chicago Central Labor Council, who read the testimony of horrific experiences of harassment by their union sisters as an organizing strategy to engage men as allies. And so that creative strategy, starting with worker voice, was key in contributing to the passage of a city ordinance that included policy and training initiatives. Diagonal to that is a groundbreaking report called The Glass Floor from Restaurant Opportunity United that talks about the relationship of sexual harassment, gender-based violence, race discrimination, and the structural inequalities of tip minimum wage that has a great impact of women, women of color, and transgender workers. And then finally, the Legal Network for Gender Equity and Time's Up Legal Defense Fund is housed and administered by the National Women's Law Center, who are able to provide access to resources for women like those in the Ford plant who need to have representation and see justice in dealing with a historically, traditionally male work environment. And so when we're looking at issues of cultural and organizational change, we really need to think about what are all of those strategies that can go beyond, frankly, the narrow legal definition of the law. The next slide. So my framework is coming from my experience in the early days of this movement as the counseling director at Working Women's Institute, one of the pioneering organizations like 9 to 5, like Equal Rights Advocates, like Alliance Against Sexual Coercion, that dealt with this issue. And I was the counseling director, and in that role, I was qualified to testify in court as an expert witness. And I want to just talk a little bit about my experience as an expert witness, because it really frames issues that relate to why didn't someone speak up? If it was such a big problem, why did they keep quiet? Why did they only raise it when they were in job jeopardy? Or if it was that bad, why didn't they tell someone before it escalated? And so we've seen in the media why, the shame, embarrassment, humiliation, and the cost, the individual strategies of how someone determines, in my experience, when to speak out is often mediated by these four frameworks. What is their personal conflict style? What's the cost-benefit analysis of opening your mouth or keeping it shut? Are you going to be slammed? Are you going to be seen as not having a thick enough skin to negotiate a contract with the boss? Are you are you being accused of selling out the movement because you're going to raise this and it's going to get in the way of a campaign? Is the retaliation for speaking out seen as disloyal? Or is there an openness and an encouragement of addressing this issue? So what is that cost-benefit analysis of opening your mouth or keeping it shut? We do this calculus all the time. It's not just about being assertive. What's the organizational track record in addressing and resolving the issue? And what are the organizational resources for advice, problem solving, complaints, and protections against retaliation? I also want to mention that those who want to be allies may also experience a different form of retaliation if they speak out and challenging the cultural norms of a workplace. So I was an expert witness in a case called Lois Robinson versus the Jacksonville Shipyards, and she was objecting to visual materials of a sexual nature that were pervasive in the shipyards. And in reading the deposition materials of 3 men who were witnesses, they admitted in the deposition that they were offended for personal, political, or religious reasons, but none of the men spoke up. So I'm going to ask folks, why do you think in the shipyard, predominantly male, assertive, I'm playing with a stereotype here, ship workers, why, if they were offended by behavior, did they not speak out? Ben, would it be possible for people just to write that in?
Yeah, they could probably put that in the question section of it, and then I can read off a few.
Okay. What do people think?
Let's see. No one wants to be a snitch.
Yep.
Retaliation. Masculine culture discourages them from speaking out or risk being called feminine and no fun.
Absolutely. So the homophobia, the heteronormative standard of what was considered to be a real man and ostracized by the peer group and being a snitch. Exactly. So don't always assume, as folks, I know on this call you wouldn't, but folks often assume all you need to do is be assertive, but it's that analysis and that calculus that folks make. And then finally, a lot of what I'm going to talk about has also come from my experience in duty of fair representation settlement agreements when unions have not represented individuals because, honey, you should be happy you got this job. You don't want to get your union brother fired, do you? Particularly in non-traditional work environments for women where the wage is higher. And also I've been part of Title VII settlement agreements against employers, including unions, who violated their employer responsibility under Title VII. So that's the framework and context from which I'm going to be making some of these comments. Next slide, please. So I want to talk about the three key components of union and worker-centered strategy for workplace equity. And I want to identify two resources that I have found really instructive. One is identified in your resource list so that you'll have the link to it, but the Select Task Force on the Study of Harassment in the Workplace by the EEOC under the Obama administration. And Hai Feldblum, who was one of the co-chairs, made a presentation to a recent convening. Secretary Treasurer Liz Schuler and Trumka and other key union folks had in February, where they talked about the AFL-CIO's code of conduct and the union's obligation and responsibility to address this issue as an issue of solidarity, of dignity on the job, as squarely consistent with union values and mission. And so when I think about the key components in addressing this issue, I always locate it within union values. Issues around code of conduct, particularly as it relates to member behavior, particularly as it relates to the accountability of union and union leadership, is a key vehicle to address this issue. Concepts of mutual aid, solidarity, respect, and dignity, and framing it from the perspective of that has been a really good door opener for me. And I'll talk about how that's happened in a couple of situations that I've worked with. And in the EEOC task force, there's a really great list of leadership and accountability and other specific strategies for promising practices that I'll identify and then refer to a little later. Policies and procedures, resources for problem solving, transparent and effective procedures, addressing concerns of retaliation. How do you leverage the collective bargaining agreement, including collective bargaining agreement of unions that have bargaining units of their own employees in addition to collectively bargaining on behalf of their members? So how does that get leveraged? And public policy regulations and legislation, as Robin has identified, and as I've identified in the montage of ways in which city ordinances, state legislation, collective bargaining at the policy level can really be used to leverage strategies and make a difference. And then finally, the intersection of educational awareness and skill building. And I want to talk about the strategies of leveraging training and education and looking at this framework of workplace civility training, bystander intervention, a holistic harassment prevention effort. So not just focusing on legal compliance, but really expanding the framework to prevention. So there are a couple of key components of a workplace climate survey, training integrated into all aspects of union and worker-centered life, and follow up to identify the impact that I'm going to refer to. Next slide, please. I'm going to identify three frameworks in which I have done work with unions to invite you to consider how you might leverage your influence, how you might think about broad strategies. And so this first is the union as an employer. And the top leadership of a service sector union made a 3-year commitment to a program with allocation of resources for staff time, a train the trainers model, and union-wide implementation. And in the 2016 Promising Practices section, leadership allocating sufficient resources, sufficient staff time, and also assessing risk factors and taking steps to minimize them are key in addressing cultural change and challenging inequality in the workplace. And so I want you to know that the backstory of this 3-year commitment was the following. A female organizer was sexually assaulted on a home visit during a campaign for unorganized workers. She complained to her lead, who was sympathetic, but the complaint never made it up the reporting chain, and other organizers were sent back to this site. And so when I got this request from the union and heard about the incident that got them tremendously concerned, I offered this option of this following, and they went for it. So an educational needs audit reaching over 300 staff as a litmus test of staff priority issues on unwanted behavior. And I'm using that term unwanted behavior. I didn't use the term sexual harassment because I wanted it to be expansive and or unfair treatment and the organizational climate in which people experience that. We designed and piloted a series of 4-hour customized modules, case study driven, focusing on skill building, ally behavior, mechanisms for constructive problem solving, and complaints with feedback, so that it was customized to the particular nature of the work. We trained 15 designated staff who came from shops, union campaigns, and staff as trainers who would implement the program union-wide. And this model created a sustained leadership group to integrate this into the organizational life of the union. So I want you to, I invite Ben to go to the next slide, please. And I'm looking at the results of one of the audit questions, one of the educational needs assessment questions that I asked. This was as close as I could get 4 years ago in doing a climate survey, because that is often seen as threatening or blaming. And this was as close as I could get to understanding the context in which people learned about their choices and the context in which people made decisions. And so I took their policy and procedure and I listed in on this slide the questions that we had asked individuals. So we asked them 2 questions. The first was, sometimes you have a difference with someone at work. What are the kinds of strategies that you would feel comfortable using if you had a difference with someone at work? And so the columns closest to you are the columns that indicate the responses of what individuals chose if they had a difference with someone at work. So direct feedback to the individual was the first. They wanted to be able to problem solve. They wanted to be able to deal with that dynamic for credibility, for opportunities to resolve it at the lowest level possible, to engage in their own social agency around choice of how to deal with it. The next highest was they were going to go to a coworker for advice. So how do we engage people as allies and upstanders to participate in that problem-solving strategy? And the final one was to go to your direct supervisor or department head for advice. So when we look at training unions as employers, or any employer, we talk about training individuals on their role and responsibility. You can manage with labor's values. Unions are employers. They have supervisors. There are people who are department heads. They are the agents of the employer. They are an obligation, responsibility to address this issue. And so, so that was really informative in terms of how we crafted the customized case studies and the skill building. The second question we asked, and those are the columns behind the second columns, is when you had a serious problem that had to do with power relationships, which options would you use? And you will see the option that's the highest is go to a direct supervisor or department head for advice. The next one was give direct feedback to the individual. And then the third one was go to a senior level staffer for advice. And so this idea of skill building in an environment where there was some willingness to take risks, but also an expectation that people had training and education is primary when you think about what is a wraparound strategy to not only do skill building, but to address cultural change. And the best hope was organizational cultural change and accountability. 43% said that. And by the way, over 50% of people responded. That was over 150 people. Continuous learning environment, linking staff quality of work life to organizational mission, sort of that work-family balance. What was the biggest concern? No change in organizational culture or accountability for priority areas and seen as joke, mocked, or quick fix. 45% said that. So I just want to highlight for you in the next slide whoops. Highlight, Ben, did we lose it? Okay, thank you. Highlight for you in the next slide some of the specific skill building that we did based on the assessment of what people wanted to learn. And by the way, we asked them, what do you want to learn? What do you want your coworkers to learn? And what do you want your supervisors and leaders to learn? So how to give feedback. The next slide, please. How to hear feedback. So when we think about member-to-member harassing, the idea of not only obligation of the, not only the strategy choice of the individual to give feedback. And by the way, in no policy are you obligated to give feedback. If you are obligated to give feedback, that is totally against best practice. It's a choice and it's a gift, frankly. How to give feedback and then how to hear feedback. And so that's really crucial when you think about member-to-member harassment, because if you're going to be doing any kind of training and education, the idea of not only being responsible for responding to feedback, but monitoring your own behavior is absolutely key. Next slide, please. And then the last two things I'm going to show you is a case study, and this happens to be the case study of the trigger event that identified the dynamics, a strategy of giving feedback, and Keisha, who's the organizer, reaching out to Marlon, the department director, after she was harassed by Stu, the unorganized worker leader. And so it's a way to sort of unpack this dynamic. And if you wouldn't mind just looking at the next slide. After that, having people analyze it based on appropriate and inappropriate behavior. Where does it fall on the scale on the right side, from harmless, annoying, offensive, problematic, and harassing? What are the strategies that you want to model so that there is skill building that teaches a proactive, immediate approach? On the appropriate side, what are some of the skills that really reinforce cultural change and proactive behavior that everyone can play based on their role and responsibility? And so next slide, please. This was a partnering exercise that Shiva Diagne and I developed for the MLK event on 2018. And it was a way in which individuals in a conference setting could could analyze a workplace or union behavior that they experienced, observed, or had been told about that had the descriptors of what constituted sexual harassment, but was not defined solely as sexual harassment, because the research says if you just use the term sexual harassment, people don't necessarily understand the nuances of the behavior. And on the left-hand side, it was an analysis of where would you put it on the scale from harmless to harassing, because at any point it can be nipped in the bud and de-escalated, to analyze the power dynamics, influence, strategy change, who leveraged their power to make a difference, what challenges did you face, what could someone have done differently. So it's a really good diagnostic tool if you're going to be doing a training and education, to get a sense from the workforce of their experience and then why they did what they did and what would they have wanted someone else to do to make a difference. Next slide, please. The last two examples, I'm going to just flag and then we'll open up for questions. A collective bargaining agreement a construction union negotiated a collective bargaining agreement with an industry employer for a mandatory 6-hour training on diversity and inclusion for all of their forepersons and superintendents as part of their certification. And so just like in the construction trades, forepersons have to do all this safety and health training. This mandatory diversity and inclusion training was negotiated. And when I was asked to be part of the training team, because there were 1,400 forepersons who needed to be trained, and the union's interest was not only looking at a commitment to cultural change, but really linking the sort of historic exclusion based on sex, race, and other forms of harassment that had been the ways in which women and people of color were traditionally kept out of traditionally white male construction unions. So the union was really committed to looking at this, and a key part of our curriculum was an activity that asked participants to reflect on their spheres of power and privilege and identify ally behavior that would be consistent with union values of fairness, equity, and to continue to make it strong and secure in a market, in its market share in an increasingly anti-union climate. So really linking that to union values, but also how does one leverage privilege and power? This concept of upstander behavior, ally behavior, which a number of people are talking about as a way to create cultural change, was very much a part of that dynamic of activity. And I'll just highlight what it looked like for you in a minute. And then the union will expand this training, and they were totally open to this for shop stewards, apprentices, their hotline staff. So it's integrated into the continuing education program of the union. And of course, how can this union leverage its influence with other key employers and trade unions in the industry? Because it's not enough to train one union on a construction site. How do they leverage this influence and their power within the state to influence how other unions respond? And then, of course, an advisory council of women in the trades across industries, and thinking how we can engage that in strategies of long-term change. Next slide. This was the exercise, and you can, pull the full one up. This was as close as I could get in a short period of time to look at issues of privilege and power. And so this in-group, out-group, numeric, majority, minority dynamic of power, and having people literally reflect on when they were in a numeric majority, where was it, how did it feel? Have they ever been in a numeric minority? Where was it, how did it feel? And talking about how, as allies, next slide, individuals can both model and influence power, model in their power positions, challenge their own prejudice, be open to feedback, be proactive. And then the next slide, how can you leverage your power and privilege as an ally to make a difference? And so how do you hold other, in this case, men accountable? How do you, and then looking at the intersectionality of race, sexual identity, as well as sexual harassment. And so how does that get leveraged, and how does that get influenced? And then the last example that I want to talk about is, again, looking at that, next slide, please, leveraging bargained workplace training time. And I want to look at this as it relates to the gender-based violence framework. And communications local used an existing joint labor management work family committee to launch a workplace awareness and prevention program on gender-based violence to include sexual harassment and domestic violence as a union and workplace issue. And for this, we added local service providers and male anti-violence activists as partners. So the backstory for this is that there was a labor leader in residence at Cornell who mentioned to me in 1996 that she was looking at the union's health and welfare funds, and she noticed that a number of union members were murdered. And they were murdered by other union members. And what could the union do proactively and reactively to address this issue? And so she knew I had done a lot of work on sexual harassment, but hadn't known that I had come out of the anti-violence movement. as a community-based organizer as well. And so we co-founded the New York Labor Union Coalition Against Domestic Violence. And we really relied on leadership from our Canadian unions, and also AFSCME took a very strong leadership role, and the Coalition of Labor Union Women, in addressing this. And so we used previously negotiated safety and health training time to hold workshops on work time, the employer's dime, that that we focused on a predominantly female workforce in job titles like operator services, because as Robin mentioned, overwhelmingly women are the targets of male violence against women, and the work-related consequences of that. Because we had just recently passed a law in New York City and then subsequently in New York State that was very similar to the sexual harassment law under our human rights law. So there was the obligation not to discriminate and to take immediate appropriate corrective action and to address this issue. And so we really worked off of that existing legislation, because this was seen as this personal issue that spilled into the workplace. So we had that framework. Reasonable accommodations is what the frame is. And so we did that. And the reason why we then worked to engage men as allies was because the following happened. Two men were in a garage, and they were told by a male coworker one day that his wife left him, and he commented that he'd rather kill the bitch than let her leave him. And these two male coworkers listened. They saw them together at union functions. They seemed to be really fine and perfect couple, and they seemed very pleasant. He didn't bay at the moon or eat baby puppy dogs, right? He seemed like a regular guy. So what does he do? He knows where she works, he stalks her, and he murders her. So now they're in post-traumatic stress, wondering what they could have or should have done to address that. And building on the past program where we launched this, focusing on the predominantly female workforce, the union responded, and we then designed a program to engage men as allies with women in the service of cultural change, linking issues of power and control of domestic violence to sexual harassment, heterosexism, homophobia, bullying, workplace violence, and norms of unhealthy masculinity. And we reached over 1,500 employees and 125 managers in this predominantly male workforce. And at the end of the program, 97% of the men polled said that they were somewhat to very committed to talking with other men, that ally behavior, that upstander behavior to stop violence against women. And 99% of the men polled said they would be more willing to take a leadership role to stop violence against women. So just a couple of slides, slide 34, making that link. And male-to-male bullying is a huge phenomenon, as you've identified in that feedback about the shipyards. But there's a case that Robin Ely had done with oil riggers on a ship in the middle of the ocean, where there were these huge safety hazards because it was unmanly to admit you didn't know how to solve a work-related problem or use safety equipment. So there was unintentionally, they identified this undoing of gender stereotypes when they addressed the safety issues. So looking at workplace safety and the ways in which bullying behavior manifests as well is key in the intersectionality and framing of this issue. And slide 35, I'm sorry, the next slide, sorry. The next slide is a strategy that we used in training. It happens to be the 4 R's in how to talk with a member coworker about domestic violence and abuse, and this would also include sexual harassment. Recognize, say what you see. You seem pretty upset after that phone call. Respond, express concern. I'm concerned about you. Show support. If something's bothering you, you don't have to deal with it alone. Refer to a help source. And then how community and union resources can be developed to provide support was a way to model strategies of redress. The next slide is a way in which, next slide, that has to do with the, oh, I'm sorry, I apologize. Yeah, you were right, I apologize. Back one. Oh, husband and wife work in the same organization. They're in the process of separating. Husband constantly shows up at wife's desk when he never did before, calls her to check where she is, and sends others by her desk to check to see who she's talking to. Sends a message to her and others. You are a coworker and are asked by the husband to keep an eye on her. Read items A, B, C, and D, and tell me, following those 4 R's, which you think might be an appropriate strategy or strategies to use.
Do you want them to put this in the question box? They can type.
Yeah, that would be great.
Okay, so anyone, you can just answer in the question, answer of the webinar box questions the way you've been doing. Which one answer you think is best?
Any answers?
Looks like A, C, or A. 3 have put C, 2 put A, and then 1 put all but B, which.
Okay, all right, great. And then the last slide is a role play of a steward who is modeling those strategies because an individual is now in job jeopardy. I need to talk because I expect to get a bad evaluation. What's different? I have personal issues that I don't want to go into. I've used up my sick days and vacation. I expect I'll need more time off in the future. I respect your privacy, but can you give me more details so I might be able to direct you to a resource? I can also talk with your manager if you want. Well, it's really personal. I just want you to know if I have to get more time off, but hold off until I need it. Okay. Remember that the union has a members assistance program. Here's a card with their number. My door is always open to you. Thanks, maybe I should talk with them just in case. What do folks think about that strategy? Was that supportive? Who and helpful? Who says yes, that you think that was supportive and helpful and modeling those 3 R's?
Maybe in the questions put yes or no. If you think it was helpful, yes, no, then. Okay, one person said, I don't think it's very supportive. The steward is keeping too much distance from the member. Another said yes.
Okay, so then we would debrief this.
4 yes.
4 yeses, did you say?
Yes.
Okay, great. So we would then debrief this and role play it and discuss it. So steward's role, individuals, options and strategies, co-workers' role. So there's a lot of ways that we can frame the role plays and case studies to really address skill building in the service of training education as we look to cultural change and some of those benchmarks that have been identified in the 2016 Sexual Harassment Task Force report. So I'm going to actually, do you want to open it up to questions? And then Robin, maybe you can do the last 2 slides. Let's open it up for questions first.
The question and answer general now?
Yeah.
Okay. So if you do have questions, you can raise your hand. There's an option to raise your hand, and I'll see that, and then I can call on you. I see right now we'll start with Allison. You can go ahead and ask your question. You're live, so you can go ahead and talk. Allison. Okay. All right. right, well, we'll try to come back to her. Debbie, do you have a question? You can speak and actually ask it.
Yes. I was just wondering if anybody has done an actual survey of the many unions that we do have and sexual harassment language that they've been able to accomplish at the table. And so that other unions could also utilize looking at that type of language for when they're getting ready to negotiate.
Mm-hmm. I will say in the past that had been done, but that's a really great suggestion. And that is definitely something that can happen.
This is,
go ahead.
I was just going to say, I think the AFL is doing that, actually. I would reach out to someone at the AFL-CIO. I've been in a couple of meetings. Some of you may know they recently held a really wonderful meeting with Trumka and with leaders from the National Women's Law Center and others, and have really taken this on as a labor issue and have developed some policies and procedures, including a pledge that they read at the beginning of every meeting. And I've been in a couple of meetings with their leadership where they're in the process of collecting that language. I don't know how they're going about it, to be frank, but I would check with someone there.
I will follow up. I will absolutely follow up with that because I know that they're in the process of, they're going to be releasing their report soon after that February convening, but I will absolutely follow up.
Exactly, yeah.
Okay. Thank you. All right, Eric, you can go ahead and ask your question live if you want. You can go ahead and just ask it. Are you able to?
Can folks hear?
Yeah,
Can
go
folks
ahead.
hear me?
Yeah, we can hear you.
I think on one of the early slides at the beginning, it said, I forget, one of the laws didn't cover companies with fewer than, I think, 15 workers. Right. And I'm just wondering to what extent do these laws not cover small businesses? If you work at a place with like five employees, are there really no legal protections then?
So glad you asked. So I alluded to the fact that there are state laws. So you're right. So the federal law only covers employers of 15 employees or more, but almost every single state that has a law, the state law covers employers with one or more. So that's really where you need to go for those smaller workplaces to provide, to find laws that provide protections against sexual harassment and discrimination. Off the top of my head, I can't tell you of a clearinghouse, you know what I mean, or a website that lists every single state's current law, but they're not hard to find. If you Google sex discrimination or sexual harassment in California, they'll come up pretty quickly. I do this for my legal research all the time. Sadly, I have not found a better way to do it. But yeah, so depending upon where you are, your members are located, you should look at the state laws. In some jurisdictions, Virginia comes to mind, and California is another one. You find even cities and counties are passing laws on this topic. So you might want to just make sure that the state level is the only level where there are protections. I know it sounds complicated, that there's these multiple levels, but it works out well in the sense that each level provides different kinds of protections. As you just pointed out, the state laws will cover smaller employers, but some of the state laws, like California, cover contractors, right? Or subs, or, you know what I mean? And so you do find broader and better protection. Part-time workers are particularly named in certain state laws, for example.
And I think that very issue is one of the reasons why farm workers and domestic workers are going to Washington next week, precisely because of the limitations, more than 15 employees and and individuals who work in people's homes, that limitation.
Yes.
Yes. So this is the time to change that and leverage power.
Okay, here's someone's microphone. They don't have a microphone on their phone or their computer right now. So I'm gonna say the question. I'm wondering if you can speak about reporting, investigating procedures in the labor movement or other social justice employers. Is having an internal process worse than external reporting?
So, this is really an interesting issue, right? I'm not going to give, I think, a answer that is really satisfactory, but I want to let you know that we're in an exciting time because for the first time ever, these different models are being explored, right? So one of the examples that Casey provided with the Coalition of Immokalee Workers, they've actually provided a 24-hour support line to their employees where employees any time of the day can call. And my understanding is that that is externally run, but it's paid for by the employer, right? And importantly, that's just a process whereby employees can have a conversation with someone about something they think they saw. So again, it's not just for individuals who think they may have been sexually harassed, but also for employees who may have seen something that they thought was sexual harassment. And it doesn't necessarily trigger a complaint process, right? So that's really key, is the model that we're hearing about is creating structures that are not limited to filing a complaint. And that's just recognizing what Casey and I have been talking about, right? Which is that providing a space where employees feel safe to come forward and talk about what they've seen or experienced, and may enable and empower them to do something about it short of filing a complaint, right? And the fear of the fear of retaliation is still alive and well, and it's not going to go away right away, no matter what an employer says. And so providing a way that an individual may not immediately file a complaint, but can just learn a little bit about maybe what their rights are or kind of how things work, or maybe get some tips about strategies about how to address someone individually in a way that's productive, if it's a one-on-one situation, right? We're seeing models both run by the employer internally, right? So I've seen models where the employer, that's clearly run internally by the HR department. I've also seen models where, like the one I just described, where the employer is hiring someone externally. I will say that, how independent that is, I don't know, because it's still paid for by the employer, but, profound efforts are made to convey to employees that that's confidential, that information will not go back to the employer. These are really key things for encouraging employees. I will say that also one of the things that I'm really happy to be a part of this discussion is the awareness of the inherent conflict of interest that employee assistance programs, internal ones, and internal human resources departments, which may just be one person, have in this space, right? Because they are employed by the employer and they are often under tremendous pressure to make it go away, for lack of a better description, because that's the message that they've gotten, which is driven by a fear of liability rather than actually a desire to create an environment where there is no sexual harassment. We currently have a liability structured response to sexual harassment in this country, right? Which is every training and every structure that we have historically has been designed to limit the employer's liability, not to actually make a commitment to ending sexual harassment in the workplace. And that human resource person or EAP person gets caught in that, right? Because what that individual employee needs is an advocate for them that is not wearing the hat of limiting the employer's liability at all times. And I'm happy that that's a part of the discussions when employers are exploring developing new mechanisms for addressing this and really being open and honest, right? That there is that inherent, and I want to tell you, I have some of my best friends are HR professionals, right? These are not devils, right? These are not, let me be really clear. Like I've worked over the years with hundreds and trained thousands of HR professionals. And there are dynamite people who are really struggling and trying to do the right thing. But I'm not aware yet of a model that really works. And so these other models that are developing with helplines and external structures are good. And so I guess what I'm going to say is we don't know yet. And I do think that what works best depends on the size of the employer, the industry, the kind of employer, the location, urban versus rural. I think there's just a lot of variables that feed into kind of what model is going to work best for which employer.
There are some unions that have members who are trained up as advocates and members assistance program volunteers so that they're trained up to help problem solve with other union members. And this could certainly be something that could happen in a social justice organization as well. There are hotlines outside the organizational structure. The National Women's Law Center and others that have been identified on the website Workplaces Respond that are outside groups, social justice hotlines with sexual assault, gender-based violence framing from community-based organizations that can also help people brainstorm strategies. There's some strategies using an ombudsperson who is an outside person that doesn't always kick in liability, although there is some reporting mechanism ultimately, not a reporting mechanism, but it's within the context of the workplace, but it's an independent. Robin, do you want to talk a little bit about ombuds?
No, go ahead. I mean, you got it.
No, you continue. Yeah.
Right. Yeah. So the concept, and some of you may be familiar with this, the concept of an ombudsman is something that's used on a state level. Many states have ombudsmen, and these are truly intended to be, and actually, I can't even believe I'm going to say this, but on the federal level, an equivalent structure that's been getting a lot of attention is kind of these inspector general roles within the federal government. These are all intended to play these within entities, right? Within an organization, within a federal government agency, or within a state agency. An independent role, and they truly do have been successful in the past, right? They do play this key role, even though they are funded and paid for by the state or the entity. They have utter independence, right, and confidentiality, and their entire role, right? And if you look, you can Google healthcare ombudsman. That actually was very well utilized with the rollout of the healthcare legislation by the previous administration, right? It was this idea that we need to really bulk up this role with an individual who is trained and has expertise, and it doesn't trigger a complaint process necessarily. There's a tracking mechanism because people want to know how many people have contacted the ombudsman for what purpose. And then that information can get funneled and utilized, in a way where you remove the identifying information if the individual does not want to be identified, but data and research that informs and can change, right, how the system works. So this fits in with the concept of climate surveys and other mechanisms that universities and workplaces are now utilizing to get a better sense of really how are the programs and policies we have in place to shift the culture around this issue and understanding how well are they working, right? And so an ombudsman often would be the place where I would see the climate survey run out of as well if an employer were to have that kind of a structure.
All right, and Virginia, you can go ahead and ask your question.
Thanks. I had a question going back really to some of the first slides in the first scenario. I was just wondering a basic thing. If there's no physical touching, but the person does not say they were uncomfortable, could something still be considered sexual harassment if a person who was victimized doesn't say that they were uncomfortable? Because sometimes I've seen it's maybe a lift for the victim to admit they're uncomfortable in a situation because of how silencing a workplace environment can be. And are there some behaviors that are just like it's black and white and 100% clear it's harassment, or does it have to be that the person has to say, I'm uncomfortable?
Great question. So from a legal standpoint, I refer to the slide where I laid out kind of the elements to prove for our federal and state laws that you've experienced sexual harassment. And this is like if an individual goes forward and files a complaint with that employer or with the federal agency, the Equal Employment Opportunity Commission, or the state agency that enforces the state law. The first step is you actually have to prove it's unwelcome. And an indication that the individual says that they were uncomfortable or they didn't want it. Some cases, judges have required some proof beyond the individual saying that they were uncomfortable, especially if they didn't say it, they just felt it, right? And then they later, like 3 years later or 2 years later or 2 months later, file the complaint. The allegation goes, well, how did I know it was unwelcome if he or she did not say in the moment, right? Did not turn around in the moment and say, I don't like that, right? And so there's a lot of litigation, sadly, in that space. Getting to your point, right? Was there anything that's just incredibly obviously unwelcome? And the answer to that question is the courts have struggled, not to be gross or graphic for a moment, but you would think, and I think when it's in some instances, judges have actually said, rape is clearly unwelcome, right? The idea is like, okay, like that's kind of like unwanted sex, right? Because it's not even sex, it's a violent crime. That is clearly sexual harassment. Now, some judges have said that. Other judges have gotten caught up in the consent trap, right? And been like, well, how did they know she didn't want it? They had a relationship before, that conversation we were having before. So sadly, there are very few bright lines, but I take you back to it has to be unwanted, right? Severe and pervasive, right? You have to meet these elements to establish hostile work environment, sexual harassment under our federal law. But you raise the way you framed your question, which I really liked, was you make allowances for the fact, that at least what I heard in it was it's possible someone else saw that, right? You know what I mean? So this is, and I think, and Casey, I'd be curious to hear what you think about this. I think this is some of the most important work that we can do, is to really provide guidance and assistance to coworkers who see things that they may think are sexual harassment, right? Or again, who cares about the federal definition for a minute? Just from their human definition, right? It's like, that is wrong. I don't want to be in a workplace where one person does that to another person, right? And maybe you witness it in something about the body language, right, from the targeted individual, makes you think that they aren't uncomfortable either, but because of the power dynamic, right? That young lady, for example, is never going to speak up because he's the boss of the whole company. That's a classic, right? But you're sitting there and, like I'm almost 50, I'm sitting there and I'm like, well, I'm somewhere in between these worlds, right? You know what I mean? And I'm looking at this and I need some guidance from my employer or my union about what I do with that, because we need to respect that individual young lady's wishes, for example, right? This is a very important and dangerous place. We don't want to place her at higher risk for retaliation. She may have other reasons why she's not speaking up that you, the Good Samaritan coworker, don't know. But there needs to be, and this goes back to the hotline or the 24-hour line, there needs to be a way that I, as a coworker, can enforce our new culture, right? Enforce what I believe is the place that we've all agreed that we want to work. And for me, what that's about is not so much whether or not it meets the legal definition of sexual harassment, but whether or not it meets your individual level of like, I'm concerned and I want to make sure that people know this is happening here. So that we make sure that people get the message that, it's not just not acceptable to the person being targeted, but it's not acceptable to any of us. And so I know I've kind of gone off the topic, but I just want to say that there's very little, right, that is really clear that it's unwelcome, sexual in nature, and severe and pervasive to meet the court's definition of hostile work environment sexual harassment. And that's what I was trying to allude to before, because it's not statutory, right? It's very, it's really unfortunate. In fact, there are cases involving touching even, as I mentioned, that were not sufficient. There's a famous case called the double grope, but that's what we call it, where literally this woman was groped, her chest was groped twice by a supervisor, and the judge felt like it just wasn't enough. You mean like groped, and you're just kind of like, really? Like, how could that be welcome, right? How could that not be severe and pervasive enough? But this is why, going back to Casey's work and the structures and interventions that she's talking about, and the question earlier from one of you about is there model language in collective bargaining agreements? There's nothing stopping you all within your unions to define sexual harassment to be inclusive of what the federal and state law says, but then go beyond it. There is nothing to prevent that. And I think we need to go there. And going back to Casey's remarks, our definitions and examples and understanding of sexual harassment and gender-based violence at work need to have an intersectional approach. We do have an advanced understanding, thank you to Kimberly Crenshaw and Anita Hill and others, that the experiences of a Black woman who's being sexually harassed, or a 16-year-old Hispanic girl, or a Hispanic gay man, all of those experiences of harassment are different. And those intersectional identities mean that their experiences, the oppression that they have, the power and control dynamics are different. And thus their ability or willingness to respond or do something about it is different. And the remedies that they seek are also different than me. I'm a white woman. It's probably obvious, but I'll just say it. Like, I'm a white heterosexual woman. And so my experience right, is different when I am sexually harassed because I carry a different set of identities, right? And we can do that in our union collective bargaining agreements. We can do that if we have a good relationship with our employer and our employer policies. And we need to also make sure that it's not only complaint driven. And that's what, again, Casey's work is so good about highlighting, right? Is that to create a culture, you can't just say, well, we've got a policy that says if this happens to you, you can call this number, you know what I mean? Or you can file this complaint. If the entire structure is built upon one thing and one thing only, and that is complaining, you're not going to change the culture because you're not committed to preventing the behavior from happening in the first place.
Okay, Robin, I think also we may want to start kind of winding up. It's going to cut off here. That we've had a certain session for about 4 more minutes. So if there's too much
about that last thing. Casey, did you want to say something?
I think grounding this in union values and identifying who allies are that can leverage their power and influence in situations where someone may be reluctant to speak out because the cost is too high, but really being strategic about who else can identify and intervene in ways that doesn't put the person who may be the target at risk. And so I think that conversation is also sort of part of framing this in the cultural accountability and code of conduct framing of this, and some creative strategies that might address this issue that I can see we may be cut off, but I would be happy to continue conversations with anyone after the call.
Okay. Robin, did you have a couple more slides you wanted to go through?
Yep, just our resources here at the end. And again, I hope everyone gets a copy of the slides. So before we get to the resources, I just wanted to flag, and some of you may already know about this from your internationals, the International Labor Organization, which is the global tripartite UN-affiliated organization that has representatives from employers, unions, and government. It's the only thing of its kind, is currently considering and undergoing a standard-setting process on a global standard to end violence and harassment in the world of work. And my organization is a part of a larger global movement, including the AFL-CIO, including the ITUC, and a variety of global labor unions, to ensure that the standard is inclusive and has an emphasis on gender-based violence. And here's some information about it. And if you want more information about it, I'm happy to speak with you. But they need to hear from labor unions preceding the deliberation and discussion about it for the first time at the ILC in Geneva at the end of May. Next slide. And this is more information about that. We're running out of time, so I'm going to go to the resource pages.
What's there? Was this the page you wanted to be on?
There's a couple more resource pages, I thought. Or did you get those through those, Casey, already? I didn't see them.
I believe it's, here we go. It's coming. Next slide. Next slide.
Ah, okay.
There we go. I was like, I didn't see you do this. I was just making sure. So we mentioned throughout this presentation a lot of different resources, right? And so these are about laws, right? And fact sheets from the National Women's Law Center and A Better Balance and Futures Without Violence, who's working with the Coalition for Immokalee Workers. Next slide. And these are great resources that you put together, Casey, if you want to talk about them.
I think the Workplaces Respond on the top is important to check out. Got a lot of really great resources and links to hotlines and suggestions and strategies for those who were targets, those who were coworkers. The AFL-CIO resources, the sexual harassment link has Hai Feldblum talking about promising practices and the role that unions can play. And it also has the hands off, pants on video that Central Labor, Chicago CLC men are reading. The splinter, Black Women Historically Lead the Fight Against Sexual Harassment is there as a link, and some of the other references that are available to open up that conversation about engaging allies and ways in which to really think about a comprehensive approach to this issue, to commit to think about strategies for cultural change.
Great. Okay, well, thank you to both our presenters for participating in this. This is very insightful and a lot of great resources. I will send out a copy of the PowerPoint. I will have all the resources included as well. And thank you to everyone who attended the webinar as well. I think this was really great.
Thank you.
Thank you all. All right.
Thank you so much for all you do.
For everything you do.
All right. See you later. Bye.
Bye-bye.
Bye.